sentences. Mandatory minimum sentences have been studied extensively and have been shown to be ineffective in preventing crime. They have been effective in distorting the sentencing process. They discriminate against minorities in their application, and they've been shown to waste the taxpayers' money. In a study report entitled, quote, Mandatory Minimum Drug Sentences, Throwing Away the Key for the Taxpayers' Money, the RAND Corporation concluded that mandatory minimum sentences were less effective than either discretionary sentencing or drug treatment in reducing drug-related crime and far more costly than either. And the Judicial Conference of the United States has reiterated its opposition to mandatory minimum sentencing over a dozen times to this Congress, and noting that they severely distort and damage the federal sentencing system, undermine the sentencing guideline regimen established by Congress to promote fairness and proportionality, and destroy honesty in sentencing by encouraging charge and fact plea bargains. Both the Judicial Center in its report entitled General Effects of Mandatory Minimum Prison Terms, a longitudinal study of federal sentences imposed, and the Sentencing Commission, United States Sentencing Commission, and its study entitled Mandatory Minimum Penalties in the Federal Criminal Justice System found that minorities were substantially more likely than whites under comparable circumstances to receive mandatory minimum sentences. The Sentencing Commission also reflected that mandatory minimum sentences increased the disparity in sentencing of like defenders because they were not applied in 40% of the cases, and at the same time increased the cost as a result of the rate of trials rising from 13% of the defendants to 19% of the defendants, with no evidence that mandatory minimum sentencing had more crime reduction impact than discretionary sentences. Former Chief Justice Rehnquist spoke often and loudly about these wasteful cost increases, and he said, mandatory minimums are perhaps a good example of the law of unintended consequences. There is a respectable body of opinion which believes that these mandatory minimums impose unduly harsh punishment for first-time offenders, particularly for mules who played only a minor role in drug distribution scheme. Be that as it may, the mandatory minimums have also led to an inordinate increase in prison population and will require huge expenditures to build new prison space. He went on to say that mandatory minimums are frequently the result of floor amendments to demonstrate emphatically that legislators want to get tough on crime, just as frequently as they do not involve any careful consideration of the effect they might have on the sentencing guidelines as a whole. Now, the Federal Judicial Conference has studied mandatory minimums and has written to the House Judiciary Subcommittee over a dozen times in the last 10 years, urging us not to adopt mandatory minimum sentences, stating that they distort attempts to enforce an orderly and proportionate sentencing regimen in the federal system, and they violate common sense by requiring vastly different defendants to get identical sentences simply because they technically violated the same section of the criminal code. And we know that the title of the offense often is not a good description of the seriousness of the crime. It also creates a bizarre situation where the decision of when to release a defendant is made not at a parole hearing just before the person is released, and you can review the sentence, what he's done to better himself, where he's going to go and what he's going to do. It's not even made at the sentencing, where the judge makes a decision based on the seriousness of the crime and the particular defendant before him and all the facts and evidence in that case. But it's made when the legislature passes the criminal code. That is, of the three opportunities, I guess about the worst time to make that decision.